day, everyone, and welcome to the Jurisdictional Dilemma. I'm your host Zayani, and today we'll delve into one of the most interesting topics in civil litigation, which is service of process out of jurisdiction.
And I'm Myra, your co-host. Today we're tackling a crucial question: how and when can courts extend their reach beyond national borders to assert jurisdiction over foreign defendants? This is a highly debated issue, as this jurisdiction has oftentimes been referred to as a form of exorbitant jurisdiction.
Exactly, Myra. To understand why this is so contentious, let's start with the basic. So, in Malaysia, when someone files a claim in court, they need to file a legal document called a writ and to the opposing party, and then therefore they will be called defendant. And this step, which is called the service of process, is generally governed by the rules of court, which hereinafter will be referred to as ROC 2012, and is typically straightforward when it comes to the parties within the same jurisdiction.
What happens when the defender resides outside Malaysia? That's where things get tricky. Courts must ensure that the plaintiff follows a rigorous procedure to justify why the case should be heard in Malaysia. As Justice Pearson said in the Society General of the Paris and Dreyfus Brothers case, I think this court ought to be exceedingly careful before it allows a writ to be served out of jurisdiction.
Well said, Myra. Courts generally have authority over people within their own territory and not beyond. So expanding this jurisdiction risks imposing unfair burdens on foreign defendants who may have little or no connections to Malaysia. So that's why our ROC 2012 provides strict procedural requirements before service out of jurisdiction is allowed. For certain circumstances, the originating process can be served outside of jurisdiction, provided that an application for leave by the court is made, along with the affidavit specifying the grounds and whether the applicant has a good cause of action and in which country the defendant may or not be found.
In some cases, Malaysian courts have relaxed these procedures, treating procedural missteps as curable irregularities rather than outright nullities. While this might seem practical, it can also erode the safeguards designed to protect both parties' rights.
And that's exactly what we'll explore today. Firstly, we'll take a look at Malaysian legal framework with our legal experts, Ms. Nisa Maliha and myself, and then we'll compare it to Singapore's innovative approach and discuss what Malaysia can learn with insights from legal experts. Ms. Alisa, Ms. Amin Nazifa, and Ms. Nasha Farhana. Let's head to the studio for a deep dive into the Malaysian system.
Thank you, Ms. Myra and Zayani. So let's get right into it. The law of service out of jurisdiction in Malaysia is really a combination of the statutory enactments, rules of procedure, and case laws. To put it correctly, this amalgamation takes its backbone from Order 11 of the Rules of Court 2012, which replaced the Rules of Court 1980, laying down the basic principles on when and how Malaysian courts can assert jurisdiction over defendants outside the geographic area of Malaysia. So the Malaysian courts actually have wide discretion with regard to matters involving service out of jurisdiction, granting or refusing leave for service, setting aside service affected, and making a variety of consequential orders. So such discretion, in turn, has been guided by well-established principles of private international law and considerations of justice and fairness. So the legal framework for this service is based on a number of cornerstones. First and foremost, there is the procedural regime supplied by the ROC 2012, particularly Order 12, which sets out when service out of jurisdiction might be permitted and how it must be effected. So before the issuance of a writ, leave must be obtained from the court according to Order 11, Rule 3 of the ROC, which is intended to be served outside Malaysia. So this leave shall be applied through Form 7. This is considered a tight rein on abuse of process, respectively across international borders of jurisdiction, and the process is used only when necessary. So the granting of this permission is regulated by the relevant practice direction, which is practice direction number 2 of 1982, which outlines what one needs to do and what papers to file in order to get such permission. So without this practice direction to guide applicants, applicants may find these formalities beyond their competence, such that the applications might go through delay or be dismissed entirely due to irregularity. So apart from that, this application for the leave of the court requires a great deal of preparation and presentation of evidence. The applicant in such an application needs to provide an affidavit in Form 8 in accordance to Rule 4, so which to the last detail substantiates the reason behind his application for service out of jurisdiction. So this affidavit needs to state firstly the address where the defendant is likely to be, confirm whether the defendant is a Malaysian citizen, and state the proposed method of service. So leave shall only be granted if it is adequately demonstrated to the court that the case is appropriate for service outside of the jurisdiction in accordance with the order. So under the Rules of Court 2012, service out of jurisdiction must also comply with the law of the country where the service is effected. This is in accordance to Rule 5 of the order, which ensures that no court order or direction authorizes actions that would contravene the foreign jurisdiction's legal requirements. So additionally, Rule 5, Subsection 3 allows for flexibility in serving a notice of writ, stating that personal service is unnecessary as long as the service method aligns with the foreign country's legal framework. So these provisions emphasize the importance of respecting international legal principles while also facilitating cross-border litigation, ensuring that service processes do not create conflict with foreign laws. However, caution must be administered while issuing a writ. The reason why caution must be observed is because if procedures for applying for leave of the court regarding service out of jurisdiction are not properly followed, the issued writ may be set aside. However, concerns have arisen that the law's application may be overly rigid, as demonstrated in the case of Ciciana Srin Berhad against Saab Scania and another. In this case, the plaintiff had actually failed to obtain leave before issuing the writ against two defendants who were residing in Sweden and Japan, which led to the High Court ruling in favor of the defendant's application to set aside the service. So this case sparked debate over whether the plaintiff's non-compliance with leave application procedures should be treated as a curable irregularity or as a nullity. Following this case, the court ultimately concluded that it may exercise its discretion to validate an irregular service, though only in exceptional cases. So an example of a case that falls under the said exceptional instances was Dr. Chan Ching Chung against Chan Chat Cheong and another. So in this case, the appellant did attempt to comply with Order 6, Rule 6 of the RHC, but the form of the application was defective. The court recognized that this did not amount to a complete disregard for or non-compliance with Order 6, Rule 6 of the RHC, as the appellant had made an effort to follow procedure despite the technical flaw. Similarly, in a more recent case of Able Foods Sdn Bhd against Open Country Dairy Limited, the High Court examined whether service requirements under Order 11 of the ROC had been met when the plaintiff served a notice of writ to a New Zealand company. So although the defendant challenged the service on the grounds that it did not comply strictly with New Zealand law, the court ultimately upheld the service. The case highlighted how Malaysian courts apply Order 11 with the broader objective of justice, which allows more flexibility in technical compliance if it does not cause substantial injustice. So the court concluded that given the defendant's knowledge of the writ, procedural issues in the service method did not invalidate the notice. So this leniency reflects the court's discretion to treat certain procedural missteps as curable irregularities rather than nullities, especially when there has been an attempt to comply with the rules. So such flexibility highlighted the need for clearer procedural guidance in cases involving cross-jurisdictional service, as procedural ambiguities may lead to unnecessary disputes over technical errors that do not affect the substance of the case. But that's not all. Ms. Sayani will continue on the substantive law that goes into service out of jurisdiction.
Thank you, Ms. Nisa. Apart from the procedural aspects that the applicant needs to abide by, there are also substantive principles that need to be fulfilled in order to prove a good case before the court deems that the case is a proper one for service out of jurisdiction. Firstly, the applicant needs to ensure that the case that they are bringing must fall within one or more of the 13 names stated under Order 11, Rule 1, Paragraph 1. In applying, it is sufficient that the contents of the affidavit and statement of claim shows clearly that the application is made under one of the instances under the 13 names. Secondly, the standard of proof requires the applicant to demonstrate a sufficient level of evidence to persuade the court that the case fits within the subparagraphs of Order 11, Rule 1, Paragraph 1. The court may deny leave if it believes the case is likely to fail. In the case of Oliver Team Axman and Salka Malaysia Berhad and another, Justice of the Court of Appeal Azhar Muhammad noted that it is enough for an applicant to show a good arguable case within one of the limbs of Order 11, Rule 1, Paragraph 1, and that regarding the claim's merits, there is a serious issue to be tried. Thirdly, under Order 11, Rule 4, Paragraph 2, the court holds discretion to decline jurisdiction based on factors such as forum non-convenience or the plaintiff's failure to establish a good arguable case. Consequently, the applicant must convince that the court that it is appropriate to exercise its discretion to grant leave. The principle of forum convenience plays a vital role in guiding courts to identify the most suitable jurisdiction for the case. In this determination, the central question is whether justice is better served by conducting the proceedings in Malaysia or in another country. To secure leave under Order 11, the applicant must establish that the Malaysian court is the forum convenience. Conversely, parties seeking to stay proceedings must demonstrate that the plaintiff has no valid basis to pursue an action in Malaysia. In making this assessment, the court will consider various factors, including the connection between the dispute in Malaysia, the location and availability of witnesses and evidence, the governing law, and any concurrent proceedings in other jurisdictions. Additionally, the residence and business locations of the parties are carefully evaluated to determine whether Malaysia is the most appropriate forum. In the case of T. Chiming and Teo Ah King, for example, the court had concluded that Sarawak was the appropriate forum because most witnesses and evidence were located there, making it unjust to apply Singaporean law to the plaintiff's case. And in contrast, in the case of Hyrex Petroleum Sdn Bhd and Mans Nicholas Lidegren and others, the Malaysian court had decided that the forum convenience is not in Malaysia, as substantial amount of evidence and key witnesses were located outside of Malaysia, which would make Malaysia a less convenient forum for a fair trial. As such, the Malaysian law's strength lies in the fact that it works upon a delicate balance of competing interests, provision for access to justice, international sovereignty, and also procedural fairness. Accordingly, the promotion, development, and refinement of these rules will be of essential importance for both practitioners and courts in order to match the growing number and complexity of cross-border disputes. Therefore, with that, I conclude the explanation on Malaysian legal framework in regard to the service of process out of jurisdiction.
Thank you, Ms. Zaini and Ms. Myra, for having me. Good day, everyone. Today, I'll be diving into the Rules of Court 2021 in Singapore, particularly focusing on the procedures for service out of jurisdiction. These reforms were introduced to modernize litigation process and adapt to the growing complexity of cross-border disputes. So let's unpack what this means for international cases and how Singapore courts are navigating jurisdictional challenges in our increasingly globalized world. So to begin, the Rules of Court 2021 were implemented on April 1, 2022 and represent a significant overhaul of Singapore's civil procedure framework. The primary aim is to streamline litigation, increase transparency, and make judicial process more efficient. One critical area of reform is the handling of service out of jurisdiction, which is a procedure vital in cross-border disputes where defendants are based outside Singapore. These rules are especially relevant in today's interconnected world where international transactions and disputes often bring foreign parties within Singapore's legal system. So let's look at the procedural framework. Under Order 8 Rule 1, service out of jurisdiction requires the claimant to meet one of two conditions. First, court approval must be sought unless second, there is a contractual exception that allows disputes to be resolved in Singapore without court permission. So according to Order 8 Rule 1, Paragraph 1, to obtain court approval, the claimant must demonstrate that Singapore is either the appropriate forum for the dispute or that the Singapore court has the jurisdiction. Moreover, under Order 8, Rule 1, Paragraph 2, the claimant applies through a summons, supported by an affidavit, which details first, the basis for the court's jurisdiction, second, where the defendant is or may be found, and third, whether the validity of the originating process needs extension. So, for contractual exceptions under Order 8, Rule 1, Paragraph 3, no approval is needed if the contract designates Singapore as the dispute forum. This promotes party autonomy and simplifies proceedings, allowing the claimant to serve directly based on the agreed terms. Now, while the procedural aspects lay the foundation, the substantive requirements ensure that these cases are well-grounded. According to the Supreme Court Practice Directions 2021 and preceded cases like Zoom Communications and Broadcast Solutions, claimants must establish three key elements. First, there must be a good arguable case, and this involves proving that the claim has a strong legal foundation and is not frivolous. Second, forum convenience, where Singapore must be shown as the most appropriate forum for resolving the dispute, considering factors like the parties' locations, events tied to the dispute, and evidence availability. And third, there must be a serious issue to be tried. The case must involve substantial matters warranting judicial intervention and not speculative claims. Together, these principles balance accessibility to justice while preventing misuse of Singapore's jurisdiction. Lastly, in Cosmetic Care Asia and Sri Linarti Sasmito, the court reaffirmed three substantive requirements for service out of jurisdiction. First, there must be a good arguable case where the plaintiff must demonstrate a solid legal foundation for their claim with a substantial connection to Singapore, avoiding speculative arguments. Second, there must be a serious issue to be tried where the claim must not be frivolous and should present credible issues that merit judicial consideration. And third, forum convenience, where Singapore must be the most appropriate forum for resolving the dispute, assessed based on factors such as parties' convenience, evidence location, and the connection to Singapore. The court found that these requirements were satisfied, establishing Singapore as the suitable jurisdiction and ensuring procedural integrity in cross-border disputes. So to conclude, the Rules of Court 2021 and the accompanying case law reflect Singapore's dedication to evolving legal frameworks that meet the demands of modern cross-border disputes, whether it's adapting to digital assets like cryptocurrency or respecting party agreements in international contracts. These rules strike a balance between efficiency, fairness, and respect for international boundaries.
So today I'm going to talk about an important legal process that comes into play in the international litigation, which is the service out of jurisdiction, specifically on how Malaysia and Singapore handle this process, which, despite some differences in details, shares many similarities due to both countries following common law principles. Now, service out of jurisdiction means that when a legal dispute involves a party who is located outside of the country, the court needs to grant permission before any legal documents, like a writ or summons, can be served on them. So this process ensures that a jurisdiction isn't overstepping its boundaries, especially when the defendant isn't within the borders. So both Malaysia and Singapore are careful about how this process is handled to avoid any potential misuse. So the key concept here is that the courts in both jurisdictions require that an applicant obtain leave of court, meaning that you must get the court's approval before you can serve the legal documents on someone who's outside of the jurisdiction. And this is very crucial because without the court's permission, any service done outside of the jurisdiction is considered irregular. And in fact, there's a famous case from Malaysia, which is called the Leal against Dunlop by Process International in 1984, which emphasizes how serious this is. The court in that case ruled that if you serve someone overseas without leave, it's an irregularity, so severe that the court won't simply overlook it. Now, how does this process actually work? In Malaysia, the procedure is governed by Order 11 of the Rules of Court 2012, and the application for leave must be made on an ex parte basis, meaning that the applicant applies without the other party being present. And the applicant also has to support this application with an affidavit. And one of the key requirements is that the applicant must show a good arguable case, which means that they need to demonstrate that there's a valid legal reason for Malaysia to hear the case. And the case must be connected to Malaysia in some way, such as if the contract was made in Malaysia, or if the case involves property in Malaysia, or if the relief sought is closely linked to Malaysia. Similarly, in Singapore, the rules are found under Order 11 of the Rules of Court 2021. Like in Malaysia, an applicant must show a good arguable case for why Singapore is the proper forum, and the court wants to be convinced that Singapore is the most appropriate place to hear the case, or that there's a real issue to be tried in Singapore. So this ensures that the applicant isn't simply trying to drag a case into Singapore because they think they'll have an advantage there. So now we can see that both countries are very clear about one thing. These applications must be supported by convincing evidence. And the applicant needs to make a strong case for why the court should be allowed to assert jurisdiction over the defendant, especially when the defendant is outside of the country. And full and frank disclosure is also required, which means that the applicant must provide all the relevant facts, even if some of them are not in their favor. So since these applications are made on an ex parte basis, the court relies entirely on information provided by the applicant to make its decision. One thing that both jurisdictions make very clear is that forum shopping, which is when someone tries to choose a jurisdiction that they believe will be more favorable to them, is not acceptable. The courts want to ensure that a case is being brought before the correct forum and not just the one that's most convenient, which is why the rules for service out of jurisdiction are so strict. They prevent a situation where a party could try to use the legal system to their advantage by unfairly asserting jurisdiction over a foreign defendant. So finally, to summarize, both Malaysia and Singapore require that an applicant get permission from the court before serving legal documents outside of their borders. So they each have a process in place to ensure that the jurisdiction is only asserted when there is a valid legal reason. And the applicant must also demonstrate a good arguable case and be transparent with the court, providing all relevant information to avoid any potential misuse of the system. And the process is designed to maintain fairness and prevent any unjustified expansion of a court's jurisdiction, which is vital in cross-border legal disputes. That's all from me. Now we will have Ms. Nasha to tell us the differences in the legal approaches.
It's an absolute pleasure to be here today, so first of all, thank you Ms. Sayani and Ms. Myra for having me. Now, before I dive into the differences, let's set the stage with a little thought experiment. Imagine this, a Malaysian entrepreneur locked in a contractual dispute with a Singaporean tech giant, attempting to serve legal documents across the border. Now, despite the clear ties between the dispute and both nations, the process spirals into complexity because of differing judicial philosophies and procedural rules. With that in mind, let's explore how Malaysia and Singapore approach the service process out of jurisdiction, and more importantly, what lessons Malaysia might glean from Singapore's innovations. Alright, so let's begin with Malaysia. Our courts operate under Order 11 of the ROC 2012, as we've heard from our other panelists earlier, and this framework reflects a cautious and conservative approach. Malaysia's court places significant emphasis on procedural rigor to ensure that jurisdiction is only asserted when there is a direct and substantial connection to Malaysia. This meticulousness is also apparent in past cases such as Dr. Chan Jing Chen, because in this case, while the Court of Appeal took a different approach compared to the case of Sisiana, it was only done so to address uncertainties that might trouble practitioners applying for leave to serve out of jurisdiction. The court sought to rectify procedural non-compliance to deliver justice, but it remained clear that procedural standards must be met strictly. This vigilance also stems from a deep concern to safeguard foreign defendants from arbitrary or unwarranted claims, so that Malaysia's court do not overreach and only exercise their exorbitant jurisdiction sparingly. So, if you think of Malaysia, think of its system as an intricate old lock. It's reliable and secure, but requires precision and care to operate. So it protects the integrity of the process, but can be slow to respond to the practical realities of modern cross-border disputes. Now, let's cross over to Singapore. Under its ROC 2021, the judiciary has shifted to a more flexible approach. Instead of an exhaustive scrutiny of procedural details, Singapore now focuses on substantive connections to the forum. For example, under Order 8 Rule 1, there's a non-exhaustive list of jurisdictional gateways. This reflects a deliberate move away from rigid procedural checks because, most importantly, it evaluates whether Singapore is the most appropriate forum. This principle was also evident in the case of Zoom Communications, where service out of jurisdiction was allowed due to strong commercial ties to Singapore. The court in that case emphasized that procedural rigidity should not hinder legitimate international disputes. So, if we think of Malaysia as an old lock, Singapore is the modern smartphone. It's efficient, responsive, and tailored for today's dynamic environment. It retains security, but prioritizes functionality and adaptability. Let's also delve deeper into how this judicial philosophy plays out in practice. In the case of NW Corp and HK Petroleum Enterprises Corporation, the Singaporean court demonstrated its forward-thinking approach by permitting service by registered mail based on the Singapore Choice of Court Agreement, despite the absence of specific service location requirements in the contract. So this case reflects Singapore's intent to liberalize service out of jurisdiction in the interest of efficiency and judicial accessibility. Meanwhile, in the case of Chong Jun Yung and Three Arrows Capital, the Singaporean court broke new ground by addressing digital assets like cryptocurrency. So in this case, control over digital assets was deemed sufficient to establish jurisdiction, provided a strong connection to Singapore was demonstrated. So this cases highlight Singapore's ability to adapt to the complexities of modern international disputes, particularly in the digital economy. It's a signal for Malaysia to consider updates to its legal framework to remain competitive in a rapidly evolving global landscape. Hence, if we were to summarize the differences, it would be as you can see from this table. So what can Malaysia learn from Singapore? Well, to me, Malaysia and Singapore represent two ends of the spectrum, Malaysia's cautiousness versus Singapore's flexibility. Both approaches have their merits, but as the world changes, so must our legal systems. By adopting lessons from Singapore's efficiency and innovation, Malaysia can modernize its legal framework while maintaining the fairness it values so deeply. That'll be it from me. Back to you, Ms. Layani and Ms. Myra.
Now, let's shift our focus to the lessons Malaysia can draw from Singapore's approach. Singapore's efficient, well-structured rules and detailed rules of court offer valuable insights into refining cross-border service procedures. To illustrate this, we'll compare Singapore's rule of court with Malaysia's framework to highlight the differences and show how Singapore's detailed rules provide a more effective model. Firstly, Singapore has a more streamlined process for service of foreign documents as seen under Order 8 Rule 5. Both Malaysia and Singapore facilitate service of foreign documents via the Ministries of Foreign Affairs. However, Singapore's Rule 5 offers a more clear guideline for translations, certifications, and handling foreign state parties. In contrast, Malaysia's Rule 6 lacks this level of specificity. Adopting Singapore's structured framework could enhance Malaysia's process, ensuring better clarity and consistency.
Secondly, Singapore is more flexible in terms of service methods. Singapore's Rule of Court, specifically Order 8 Rule 2, provide flexible options for serving documents internationally, including via contractual agreements, conventions, or consular authorities. This enables parties to select efficient methods suited to different jurisdictions. In contrast, Malaysia's approach under Order 11 Rule 6 could benefit from broadening the permissible service methods, particularly for jurisdictions governed by complex or restrictive rules. Thirdly, Singapore's Rule of Court, Order 8 Rule 7, requires solicitors to formally undertake the payment of all expenses for service abroad, with a 14-day deadline for payment upon request. Malaysia could enhance its own Order 11 Rule 8 by adopting a similar requirement, ensuring clarity on cost allocation and avoiding disputes. Next, Singapore's Order 8 Rule 8 allows an official certificate of service from a foreign agency or individual to serve as a sufficient proof that service was properly carried out under the foreign country's laws. Malaysia could adopt a similar provision where such certificates are accepted without requiring additional authentication from local authorities. This would simplify and expedite the international service process, reducing delays. Other than that, in Singapore, the court must approve the service method for documents outside its jurisdiction, ensuring the correct jurisdiction and method are chosen. Malaysia's Order 11 Rule 9 also requires court approval for service outside its jurisdiction, but the process lacks the detailed guidelines found in Singapore's rules, which would specify factors such as jurisdiction and appropriateness of the forum. But besides adopting more strict and detailed rules of court, we can also improve through other means, such as simplifying service procedures for the ASEAN region. Malaysia could consider adopting a simplified approach similar to Singapore's Order 8 Rule 3 for service within countries like Singapore, Brunei, or Indonesia. This will allow for faster service processes through local court officials. Besides that, we could also create a dedicated international service division within the Malaysian courts, as it would significantly enhance the efficiency of handling service of process issues involving foreign jurisdictions. Such a division would focus on coordinating the service of documents across borders, which is often complicated by different legal systems, languages, and diplomatic protocols. We can also collaborate with foreign governments and international bodies, such as being a signatory to the Hague Conference on Private International Law, which is under the Hague Service Convention that we are a member of. This cooperation would help align Malaysia with global norms, enabling streamlined cross-border processes for serving legal documents. Lastly, we could also improve Malaysia's practice directions for serving documents out of jurisdiction by having clear step-by-step guidelines, standardized forms, and detailed instructions on affidavits and documentation. In conclusion, improving Malaysia's approach to cross-border service of documents require a combination of adopting best practices from more structured frameworks such as Singapore's and refining its own processes. By enhancing clarity, flexibility, and international collaboration, Malaysia can streamline its procedures, reduce procedural delays, and ensure a greater consistency in handling cross-border legal matters. Emphasizing a more detailed, systematic framework coupled with stronger international partnerships would not only improve legal processes but also enhance Malaysia's standing within the global legal community. These changes, in turn, can foster a more efficient, transparent, and predictable legal environment for both local and international stakeholders.
So, to wrap up, we've discussed the service of process under jurisdiction, covering both Malaysia and Singapore. We've seen how these legal frameworks navigate a delicate balance between upholding local judicial authority and respecting international law.
That's right, Narini. We highlighted how Malaysia's Rule of Court, particularly Order 11, and Singapore's similar rules ensure procedural fairness, strict adherence to criteria to guard service out of jurisdiction, and it's interesting to note the similarities as well as the differences.
Ultimately, the discussion underscores the importance of ongoing reformation and assessment to keep up with the international standards. Balancing jurisdictional authority with respect for foreign sovereignty remains a complex but necessary endeavor.
Absolutely, Zani. By learning from jurisdictions like Singapore, Malaysia can strengthen its position in handling cross-border legal disputes, ensuring both fairness and international cooperation. With that, we conclude the jurisdictional dilemma. Thank you, and stay tuned for the next episode. Bye!